Okay, just a little housekeeping. If you look at your control panel, you'll see that there is an orange arrow to the left. You can minimize the control panel by using that. You'll also see that there is a questions drop down. If you have any questions during the course of the webinar, just post them there. And I think that's about all you need to know about the control panel, with the exception of the handouts. There is a handouts drop down too. So you can download handouts from there. We are pleased to present this webinar series with the University of Florida Levin College of Law Institute for Dispute Resolution. And now we're going to go ahead and get started with Terry White.
Good afternoon. I'd like to welcome everyone. We have an extraordinary grouping of attendees, close to 100. I think that's because they saw a lot of talent that was available in this seminar that they wouldn't have a chance to appreciate otherwise. So I want to thank all of our panelists for making themselves available. You know, as a firm, we've tried to dedicate energies and efforts towards an area that a lot of people just don't function in often. And so now's the time for everyone through Steve to, as our head of the panel, to explore, you know, what are some of the things that work, what are some of the ones that don't, and from a very, very talented pool of individuals. So I'd like to welcome everyone and kick it over to Steve.
Thank you very much, Terry, and thank you for joining us this morning, or this afternoon. We bring you this lunch and learn webinar, and it's not only lunch, it's going to be coffee for some of the people on the West Coast. On behalf of Upchurch, Watson, White, and Max, we established a year ago a class action resource center, and our vision is to bring the most up-to-date programs to the class and mass action bar. We want to be trendsetters. We want to bring the industry leaders together to discuss issues, trends, so that the practitioners in this space can lean in, and hopefully you enjoy that journey. This webinar today, well, first and foremost, let me do this. Let me welcome everybody from across the country for a lunch and coffee learn. It's not your normal traditional legal webinar. I have always been interested in why people do what they do. One of my why answers is Grandma Lily. Grandma Lily was a top academic coming out of her high school, forced to go to secretarial school. She was lucky enough to become a JA with a gentleman for 25 years. She should have been a lawyer. And as a result, she pushed me to go to law school. So today, for Grandma Lily, I bring together 4 of the top women litigators in the mass and class action practice area. Women who lead this industry that is traditionally occupied by men. For the next hour, my goal is to learn how they rose to the top of their field in the law firms they practice in and in their professions, and to lead in some of the largest class and mass actions in our country. Why did it happen? My hope is to inspire, to get insight and suggestions from this fine panel to help identify common personality traits found in leaders, how and where to find leadership positions, how to develop and mentor young women in all professions so that they can take their seat at the table. And if time permits, get some opinions on some emerging areas of law. So let's get to our panelists. Ariana Tadler joins us from New York. Ariana became interested in law at a very young age when she traveled to Haiti and saw impoverished people that could not help themselves. Ariana went on to be named one of the 500 leading women lawyers in America. She was in the leadership group that settled a $586 million settlement involving securities litigation. She is one of the foremost experts on e-discovery matters in the country. She joined a class action firm, Milberg, in 1997 as an associate. By 2004, named to the firm's management company. And by 2008, elected to serve on the firm's executive committee of 5 and the only woman. After many leadership roles, she formed her own law firm called Tadler Law in 2019. It is a WBENC certified women's owned law firm. She's AV rated, best lawyers in America, super lawyers, Law Dragon, and on and on. My friend, Ariana Tadler. Amy Keller joins us from Chicago, co-lead counsel in Equifax data breach that occurred in 2017. Youngest woman ever to be appointed to serve as co-lead in a nationwide class action. She's also co-lead in the Marriott data breach case, American Medical Agency case, Electrolux. She's on the executive committee of the Apple device performance litigation and co-chair of the law and briefing section. Two-time chair of the Chicago Bar Association Class Action Committee. In 2016, elected to the board of directors of Public Justice. They fight social injustice. In 2018, she was named to the National Law Journal Plaintiff's Trailblazer. Named by Profiles in Diversity Journal as a woman worth watching. In 2019, she was joined and named as a partner in Dicello, Levitt, and Gutzler, who has 4 offices. She's out of the Chicago office. 6 of the last MDL leadership appointments. She has been named to leadership appointments in 6 of the last 4 years, more than any other woman in our country. Welcome, Trailblazer Amy Keller. Sheila Birnbaum, co-chair of the Products Liability and Mass Tort Practice Group for Dechert, LLP. Sheila's firm was established in 1875, became Dechert Price in 1962, and today operates under Dechert, LLP. 22 locations worldwide, more than 1,000 lawyers. She represents the largest, and along with the firm, 40 of the top 100 Fortune 100 companies in the world. She's one of the premier products liability defense lawyers in our country, has argued in front of the appellate courts throughout this country, as well as the US Supreme Court. She was co-lead in Purdue Pharma opioid litigation, co-lead in Pfizer MDL regarding birth defects. She was the first woman to be a tenured professor at Fordham Law School. She was associate dean at NYU Law School, co-founder of the National Conference for Women Bar Associations, AV rated, who's who internationally, and my favorite, she was court-appointed mediator for 92 families of the 9/11 victims she helped resolve a $500 million resolution in that matter, and she was special master to the September 11th Victims Compensation Fund and distributed over $2 billion to claimants. Sheila is a legend. Thank you for joining us, Sheila.
Thank you.
Michelle Drake, National Law Journal named Michelle 2020 Elite Women in the Plaintiff's Bar. In 2021, Plaintiff Lawyer Trailblazer. Michelle graduated from Harvard. While at Harvard, she was an intern for the Louisiana crisis and on a team defending a nurse in a death penalty case. So she followed her pursuits in 2001 down to Atlanta, where she became a public defender for 6 years, then moved back to Minnesota, where she began her class action career. Michelle has served as lead counsel in over 50 class action and collective actions. She found her way to the Fair Credit Reporting Act, Fair Debt Collection Practices Act, Fair Labor Standards Act as an expert. She's also been named to Super Lawyers, is an AV lawyer. In 2008 and 2009, 2 of her cases were named Lawsuit of the Year by the Minnesota Law and Politics. 2016, she joined the firm of Berger Montague and opened the first office outside of Philadelphia in Minnesota. 2016, as I said, she was named a shareholder, and in 2021 elected to their executive committee. Michelle was lead counsel on the largest Fair Debt Reporting Act class action case of approximately $15 million. Lead counsel in the first ever MDL involving Fair Credit Reporting Act. Is she on the executive committee of the Jewel mass tort litigation? Interesting to note, Michelle says that she's never been out negotiated, except by her husband and her 2 kids. Thanks for joining us today, Michelle. All right. With that being said, Sheila, let me ask you the first question. You graduated NYU Law School in 1965. Tell our attendees what pushed you into the law, specifically litigation, back at a time where it was completely a male-dominated industry.
Well, thank you for having us. It's a pleasure to be part of this panel. I know some of you personally and others I'd like to get to know. I feel like I'm the only defense lawyer here, but I'll hold up my own against all these wonderful plaintiffs' lawyers. In 1965, even thinking that you wanted to get into a courtroom and be a woman was sort of strange. People looked at you strange. I mean, when I first went into courtrooms, sometimes the judges in New York would look down and say, "Where's your lawyer?" Thinking, how can you have a woman standing up in the courthouse? But I don't know how and when I wanted to be a lawyer, but in the 6th grade in my autograph book, I have down profession lawyer. There were no lawyers in my family. There was no one even in my family that had graduated college. So it's a long way between the 6th grade and going to NYU Law School, which was a wonderful place and very open to women, even back then. So it's just something that I dreamed of and have not regretted one moment of being a lawyer. And since everyone on the phone is probably a lawyer, looking backwards is not really helpful anymore. I think we all need to look forward. Things have changed dramatically for women in law, all in the right direction. There's still more to do, but with the wonderful lawyers on this phone and probably those who are watching this webinar, I think we're gonna get there all the way. So thanks, Steve, and a little reminiscence about the past is a good place to start, I think, but now we need to get to the future.
Very well. Thank you very much. Ariana, you graduated Fordham Law in 1992. In reading your bio and knowing you as I do, you made your way into the class action arena and you found yourself in a large class action with it. You saw some opportunity. I'd like you to discuss with us how you saw the opportunity within the discovery arena to manage people using your high school state championship lacrosse background, if you would, to lean in and ultimately get to leadership.
Sure. Thank you, Steve, and to the entire team. It's really a pleasure and a privilege to be here today. I've always been very team oriented from the time I was quite young. And you mentioned that I was a lacrosse player. I was actually a goalie. And I think that really helped tremendously in terms of always looking at the landscape, looking at the field, thinking about who are you working with, collaborating with, what are you trying to achieve to get to the other goal while I was defending ours. And really what it came down to insofar as identifying EDiscovery as an opportunity was I was in the right place at the right time. I'm a math minor as well as an English major. I always wanted to use some of that math side of my brain. And oftentimes jokes are made about lawyers not liking math. That's not true for all of us. And so discovery really was evolving in such a way in the late 90s, early 2000s, where big corporations were very accustomed already to using technological solutions, but plaintiffs' lawyers and class action lawyers were not necessarily yet attuned to that. And so I had a very large litigation that had a lot of data. There were 55 investment banks involved, plus another 309 corporate issuers. All of their discovery information, or the majority of it, was going to be extracted from digital and electronic information. And so we had to find solutions. And I was very fortunate to work with another lawyer from the space who kind of brought me along and taught me what he knew. And then I just found it so fascinating. I kept building on it and building on it to the point where I found that it was a path for me to take, in addition to my litigation prowess and being able to litigate front to back on any case. Most lawyers really hated discovery. And so this was really a chance for me to shine and do something that others didn't like to do, and also really kind of grow that area and help the law evolve in a way that was favorable to all, not just favorable to the wealthy or the people who were better privileged, or companies who were better privileged in that regard. So it created a lot of opportunity. And as you know, in 2015, I spun off an EDiscovery company, Meta EDiscovery, to do the tech side, and still now work very diligently to evolve the law in a way that's consistent with Rule 1, right? Just, speedy, and inexpensive. We're supposed to do that for everybody, not just for a select few.
Beautiful. Thank you very much. Michelle, double Harvard grad, studied at Oxford. How'd you find your way to the Fair Credit Reporting Act? How'd you become an expert? And how about why?
As with most things in my life, I think it was just a lot of luck. I mean, I went to law school planning to be a death penalty defense lawyer, which is really what I did while I was in law school. I worked on that death penalty case that you mentioned. Actually lived in a different city for half of the time I was in law school because I was working on a death penalty trial in federal court. And then I moved down to Atlanta and I did criminal work, and I loved it. But ultimately decided it wasn't a sustainable career path for me. So my first interview in any civil law firm was when I had been a lawyer for 7 years. And I chose the firm where I first started largely because a lot of the partners there used to be criminal defense lawyers. So I figured we would at least have something in common and a shared perspective on the world. And it was just a very fortuitous choice. I had wonderful partners who tolerated the belly flops I performed for the first couple months that I attempted to be a civil lawyer. I learned that Rule 16 letters and letters about discovery, meet and confer do not actually mean you're going to go to jail, no matter how mean they are. And once I kind of figured out that civil lawyers can be a lot nastier than criminal lawyers, then I was just off to the races. In terms of practice area, I really lucked into the Fair Credit Reporting Act, and it just turned out to be an area of law that intersects with a lot of things I'm interested in. I really like working with large data sets, and I do not like it when nameless and faceless institutions have a lot of power over regular people. And credit reporting agencies not only possess a ton of data that they, periodically release into the ether when Amy Keller starts to get involved, but they also intentionally publish a lot of information about all of us, and their procedures are so automated that often when they make mistakes, it's systematic. And so they're really kind of the perfect intersection of social justice, but also a really nice avenue for pursuing class action litigation. And I really like it. I like what I do. And in the criminal context, a lot of people's criminal records are included in tenant screening reports, employment applications. And so it's really allowed me to bring to bear my criminal background, recognizing that criminal records don't really lend themselves to automated reporting very easily. So a lot of mistakes happen there too.
Amy, 2008, you graduate John Marshall, now known as University of Illinois School of Law. Law review. How'd you find your way to data breach cases? Why?
Well, thank you. Thank you, Stephen. Thank you to my wonderful panelists for all joining us today. It's always a pleasure to speak with you, amazing women. I started out law school at what was then known as the John Marshall Law School because they had a historic preservation program. My father was a pharmacist by trade, but he was a woodworker on the weekends, and established in me an appreciation of old things and old woodworking and really fabulous hand-hewn logs and supporting structures. And so I wanted to go to law school to preserve that, and I thought it was really important to recognize your history and appreciate the past. So I went to law school for that. I got an internship with the City of Chicago Department of Buildings, but they had a budget problem, so I wasn't able to be paid. And one of my former professors, when I went to the University of Michigan for undergrad, said, my cousin has a class action law firm. You are a bleeding heart liberal. You will probably fit in quite well. Give him a call. And so I did. And like others today, I completely lucked into something that I'm incredibly passionate about. So I learned and grew at those at my first firm. I then had an opportunity to work with some amazing people at my second firm, and now I've landed with an amazing group of folks over at Dicello Levitt. I started doing consumer class action cases because I just had this feeling of fundamental fairness. I was bullied as a little kid, so I never really appreciated when big, powerful people silence the little guy or were threatening to the little guy. So I always carry this appreciation of fundamental fairness with me wherever I go. And when I started at Dicello Levitt, I told my partner, Adam Levitt, that I have an interest in technology. I'm a millennial. I learned how to code back in, I guess it was middle school. I took a class or two, and I understand technology. And so when the Equifax data breach occurred back in 2017, my partner approached me and said, how would you like to put your hat in the ring for co-lead counsel? And I thought he was nuts, because my first time, that would be my first time really leading a nationwide class action in a formal appointed role. I had led cases before, behind a partner, but actually doing all the work. And so I thought he was a little nuts at first, but then I had support from my amazing colleagues and co-counsel, including Ariana Tadler, who supported me and threw their weight behind me and thought that I could do it as well. And I learned a lot through that experience, and just felt like it was a natural fit. It combined my love of technology, and it also played into this idea of fundamental fairness, because I do think Americans are really being gaslit by all these companies that have data breach and security failures every single day, but don't tell anyone about it. So I just think that it's a natural fit for what I'm inclined to do. And then in terms of the historic preservation stuff, I still do that on the side. I work with the Chicago Art Deco Society as a board member, and I just landmark buildings, in my free time. So that's how I got into data breach cases.
Thank you so much. Let's do a quick group question. And I entitled it Lean into Leadership. How does this happen? How did, from both sides? Sheila, how did you develop and get into leadership in the defense of these cases? And for the rest of the group, how did you get into leadership? Amy just told us her story, but how did you get into leadership? And let's just have a chat about that. What guidance can you give to the audience that we have?
Yeah, look, I think from a defendant's point of view, if you're representing defendants in class actions, it's a little different than what you have to do on the plaintiff side to get into leadership, because you are hired by a company, and that you don't have, it's not, court doesn't have control of who's going to be on leadership with regard to defendants. That's all determined by the clients, who the clients choose to represent them and who they want to stand up in the courtroom and take a leadership position. And I think in the early days when I was doing this, all of my mentors were men and all of the clients were men. and that's who were general counsels of corporations in the United States, and even heads of litigation. I had very few women clients. But as I think I understood what was going to happen in the future as more and more women entered the legal profession, that these jobs were going to start being taken over by women. And it took about 10 years. But I'd say now that majority of my clients, corporations, are women general counsel, women head of litigation, and they don't come to the table with the same biases that men had in the early days, although I must say I did pretty well even then, and even when all my clients were men. I think I was lucky, like everyone else on this panel, how you fall into things. My moot court problem when I was in law school was strict liability and products liability.
Wow.
Believe it or not, we had disputes about what products liability should look like from a legal point of view. And I went into teaching after 7 years of practice, and I taught products liability. So I had an understanding of the issues much greater than most people. So I got hired then because of my expertise that I developed in a growing area of the law. And that started my leadership ability. And like everyone else here, I wasn't shy. Shyness doesn't work. And I loved being in the courtroom. I loved being doing the appellate arguments that really established a lot of the law in the products liability area. So I got hired early on because of my expertise, which is what all of you are talking about as well, getting expertise in a substantive area as well as the procedural area of class actions. So all in all, I think today it's much easier for women on the defense side because of all of those that are litigation heads and GCs. And another issue, and we can talk about this more later, some of the cases lent themselves to women lawyers. I mean, they involved women. And people started thinking, well, maybe we ought to get women lawyers into the courtroom because they will be able to cross-examine women plaintiffs in a different way. They're more sensitive. They'll understand these issues in a different way and be persuasive to juries. So I think from a defense perspective, two things have really come together. One is the nature of the cases, which opened up the field to women lawyers. 10 years ago, you didn't have women defense lawyers being first chairs. Now I could point to 3 or 4 or 5 litigations where women are all leads from the defense bar's point of view. So I think there has been a sea change in leadership, and women, as they got more experience, had more leadership abilities, and have taken over leadership in many of these very large class actions and mass torts.
Perfect. Thank you so much. Let me let me ask another general question, but before I do, I want the attendees to understand, these women on our panel have been the forces of change. They have taken a seat at the table, as you hear. They've lectured in courtrooms. They've taken the lecture in courtrooms all across America. So I want to ask this to the panel. Do you think there's a common characteristic that you all share?
Yes, for sure. And then there are differentiators. I think one of the characteristics that we share is that we've all had to push hard and lean in and make a way for ourselves, oftentimes when we were the only woman in a room. And oftentimes also, you have to understand, in the class action bar and the plaintiff's bar, there's a lot of ego that goes on. And so when you come in the room and you want to make a way for yourself, you have to find your voice. And your voice, I believe, over time throughout the course of your career is going to change. And some people are going to like it and some people are not. And that includes the people you even work with internally at your own firm, because as you're growing, you're finding new ground. And you have to be mindful about how do you communicate with all the different constituencies that you are engaging with, from the people in that room, in the courtroom, people that you're working with. And I do think that the differentiators are that you've heard from each one of us. We had really very different interests or passions that enabled us to find a unique path. And I believe for all of us on the plaintiff side, and I think this is true for Sheila too, you know, those interests and passions were ones that weren't shared by the men in the room. And so it just gave us a natural pathway. And then we had to keep pushing forward. I regularly say, push forward, pull forward. We need to do both. And we'll talk, I think, a little bit later, Steve, about how critical it is to have mentorship and sponsorship. Those are two very different things. I can say that I am absolutely the beneficiary of Sheila Birnbaum's sponsorship. There are times where I know she's put my name in for a speaking engagement or for a committee. We are on opposite sides of the proverbial V. So I think that's another thing that we share among this panel, that we get it. And while I would like to be lead in every case, the truth of the matter is, for Amy and Michelle, I have absolutely supported them because it's critical that we bring people up to make it more fair and equitable and appropriately representative of what the class context and constituency is.
So before I move on, because I have a perfect segue here, Amy or Michelle, do you want to comment directly on that? If not, I'm going to ask you both the next question.
I would love to comment. Thanks to Ariana for reminding me. I have obviously been the beneficiary of women who have been in this profession before me and have been working so hard to demonstrate that women are more than capable of taking on these roles, and in many instances can do them a little bit better. But I absolutely would not be here if it weren't for the women who have been demonstrating their capabilities in and outside of the courtroom. And not only have women opened the door by working so hard and accomplishing so many great things, but they've also, like Ariana mentioned, they pulled other women through that door. I, have now been appointed co-lead counsel in a number of cases since Equifax, and Ariana has been constantly championing me. Michelle has been constantly championing me. Sheila, I get along with very well. And I know if I asked for her support, she would give it. Because for whatever reason, I feel like when it comes time to throw your hat in the ring for a leadership position in an MDL, women are incredibly supportive of each other. It can turn into quite a difficult, we call it a beauty contest. And I think that term was coined by men. When it comes time for appointment in some of these positions, and I felt like the process among men has been super hyper competitive, sometimes a little too competitive, and among women it feels very supportive. We text each other great job when we're appointed, even if we're competing against one another. So I think women just have this natural tendency to just be incredibly supportive of one another. And I think it's important that we remind each subsequent generation of women litigators that you have to continue bringing more women to the table, because otherwise, you're just going to have a small group of litigators at the end of the day with the necessary experience to lead these cases. You have to continue to include the next generation of litigators in order for us all to be successful.
Very good. Michelle, do you want to comment, or I'll move on and give you the next question? Unmute yourself.
Just want to say this. 1,000 times yes to everything that Sheila and Ariana and Amy have said. And I would add that it is not only women supporting women, which we have all benefited from tremendously. It is also men supporting women. And now that we are in positions of power, women supporting men who support women, right? Because what good is it to have, a female lead with a male co-lead who won't listen to her, right? It's like it's all intersectional and it matters. And one of the things that we're doing in the Jewel litigation, we're paying a lot of attention to diversity. We're doing a lot of reporting to Judge Orrick about who's actually doing the work, how diverse is the PSC, and a lot of different dimensions. And it's really valuable, and it's important to think about sort of what is the underlying structure that excluded women for so long, and how can we dismantle that for everyone? Because that same structure excluded a lot of really great men and promoted a lot of not so great men. And thank you, Sheila. I was like, what's a not swear word that I know?
I'll talk after you and supplement that in a minute.
So, I'm lucky to work with a lot of men who are great. There are a lot who aren't too, but I love the fact that this is a group project. It's not just a women's project, and men are on board with it. I mean, Steve, you organized this today. We have great allies, and that and the support of other women, I'm really grateful for, and also want to turn it back around and help pull all the right people up and into good positions. And I think we all share that project.
Steve, I know you want to get on, but let me just add a point, because I think it's.
I'm not going to interrupt you.
There was an old boys club in this business, and it persisted for a very long time. And you saw the same faces over and over again in leadership in both class actions and multi-district, and they worked it out ahead of time when they came into the room, and there were trade-offs and all of that stuff. And women were excluded. I mean, in the first multi-district cases, I never saw a woman in leadership role. And there was also a lot of discussion that started coming up, and we can't lose track of the judiciary that has really played a very important role, especially in adding plaintiffs and diverse people and younger people into leadership roles in class actions and multi-district. Without them doing that, especially many women judges who took the lead, but men judges as well, who went out of their way to say, I want diverse leadership, I want women's leadership, and appointed them. And without that, there would have been a longer hiatus before you've seen these wonderful people who are in leadership roles. So we have to also give a little credit to the judiciary for changing their attitude after it was brought to their attention of the real lack of women and diverse lawyers in leadership positions in class actions. So a word for the judiciary.
And they'll be discussed in a little bit as well. Let me ask this, am I oversimplifying things? Leadership is earned through great work product, outworking others, never giving up or backing down. Or do you believe you got to ask for it, demand for it, fight for what you want?
I'll just start out by saying it's both.
Come to you.
It's both. It's really both. If you're going to sit back and not ask for it and not be in there and demanding it, you're not going to get it. And if you don't have the ability and you don't have the perseverance and you don't have the qualities, then it's not going to happen either. So I really think it's a combination of both.
I agree. You have to have all of the above and then some. And you have to know your audience. Each case is different. The people that you're working with have different personalities, different experiences. I can tell you I've worked with certain people in the bar in the past where I thought, oh, this is easy. I know exactly how this is going to work on the next one. And you get into the next one and suddenly somehow the dynamic has changed. I had a case in the course of my career with people that I know very, very well. I have the utmost respect, and found that there was some ongoing conversation without me. And I was struck by that. I thought, that's ridiculous. Why is that even happening? We're in a new era, we're collectively appointed. And I had to make a decision about how was I going to handle that situation. Was I going to come in with a lot of drama and start screaming and pounding the table? Or was I going to come in and say, okay, look, I get the sense that, or I'm feeling that perhaps there have been some conversations in which I wasn't included. Before those go any further, can I please share with you what my thoughts are? And by the way, I wasn't really asking for permission. It's a style. I knew exactly what I was doing, and got them to realize I had their number. I knew what was happening, and ultimately got everybody back on track to realize they didn't really want to have another conversation like this, because in the course of that first conversation, while I came in sort of on a soft shoe pedal, there was a part of that conversation that got heightened and was unpleasant. And I made it very clear where my line was drawn. And I was not going to move that line, not even one little millimeter. And nobody wanted to have a conversation like that again. So I think you have to really be mindful of, again, who is your audience within the team of structure that you're leading with. Sometimes, obviously, on the plaintiff side, there are multiple aspects of the structure. There's, co-leads, there's an executive committee, there's a plaintiff steering committee, so you have to be mindful of all of that. And you also have to be mindful, too, that you never want there to be an appearance of broken ranks to somebody like Sheila, because that vulnerability is an open opportunity for them to go and create all sorts of chaos because you didn't have your ranks in order. So again, I think you have to be really mindful of whom you're working with, and coming back to what I said early on, finding your voice, being able to flex that voice. Sometimes I'm an alto, sometimes I'm a soprano. Depends on the day and who I'm, singing with.
Jumping right onto that before we go anybody else, to the group, and feel free, Amy and Michelle. So are you telling me that forming leadership teams or leadership groups before seeking appointments is something that's important to do?
Yes and no, because there are some judges, there's sort of the new class of judges coming into the judiciary that you will present them with a slate that you worked on with co-counsel, and you think it's a great slate and it checks all the boxes in terms of skill sets. It has diversity, not only including women, but people of color. It has people from different backgrounds, people from different socioeconomic backgrounds. And sometimes you can present this to a court and the court says, I'm going to form my own leadership structure. So you have to really pay attention to what the court wants, because courts will often give you a cue as to what applications for leadership should look like. Some courts say, I'm considering individual applications and I will put together my own team. Some courts say, I'm considering slates but may add people. It really depends on your court. But creating relationships among folks so that they know you, they trust you, they worked with you is vitally important, because then even if you're not forming leadership slates, they will vouch for you in their papers when they submit their own individual applications. They will speak highly of you during oral argument if the judge asks who else should be on this team. So there are just some things you should think about. But I would say it's a mixed bag, and you should really pay attention to what your judge wants.
So Michelle, how were you ever made part of this group of leadership? How did you lean in?
I think it's a combination of a lot of different factors. I guess I kind of want to just make a higher level point that maybe I'll tie back to your question. So getting a leadership position is one goal, but it's not the ultimate goal. The ultimate goal is winning the case, right? And doing a good job for your client. And hopefully like actually enjoying the profession while you do it. And that's no different for women than it is for men. And so I think that one thing, and it's hard to keep it in mind because there's nothing that feels worse than getting shut out, especially in a case where you shouldn't be shut out, right? Everyone has gone after leadership in some case where it was a flyer. That's fine. But people have also gone after leadership roles in cases where they have a significant investment in the case or they have a real professional specialty or contribution that they can make. And sometimes the cookie doesn't crumble the way that it should. And the place where those relationships really come into play and they matter is what happens after the appointment. Because I've certainly been given really good work in cases where I lost a leadership fight. And I've also been appointed in leadership and maybe not been given the kind of work that I wanted or ended up doing the kind of work that I wanted, because at the end of the day, this is all relationships. And the key to, success here at the ultimate level is the same as it is anywhere, which is you have to be someone who can actually bring something to the table. And on a personal human level, you also have to acknowledge and accept that there is a lot of luck involved here and we are not always in control. And so part of the way that you end up getting appointed is you keep trying and you stick with those relationships. If you're not on somebody's slate this time, maybe you will be next time. How do you conduct yourself in those negotiations? Are you someone who makes an enemy for life over one case? I would hope not. But there are people who do. And so you have to take the long view in everything. On the case, you have to take the long view, and over the arc of your career, you have to take the long view. And at the end of the day, the goal is to be a good lawyer and get good work and to win for your clients.
So let me ask this. Has diversity in assignments gone too far?
Not even close. We got a long way to go still. It's improved tremendously. And I think it will continue to improve both on the defense side and on the plaintiff side. So this nonsense about Biden picking a black woman for the Supreme Court and people responding that it's an affirmative action. It's not affirmative action. Most of the people that he's considering have better credentials than anybody I've ever seen and better experiences. And I think it's just another way of trying to stop what is inevitable. There are just more women in the law. There are more diverse women in the law. And I think that's a great thing, and it's going to change the law for the better in the end. Women are much more collaborative. Women have egos, thank God, but not the same kind of egos of some of the guys we've seen. And I think it'll improve everything along the way. So we got a long way still to go, although we've really come a long way.
Yeah, and Steve, I'll add to that. Have we gone too far? We have so far to go. Here we're talking with a bunch of women who have worked tirelessly across not only their careers, but from the time that they were young, finding their path, living their dream, really working hard and tirelessly. Well, we're just talking about women here. What about people of color? I know from an experience that Amy and I have had, there's one particular case I can think of where we were really, really pushing for a diverse group of people in leadership. And when we say diverse, we mean people of different sexual orientation. We talk about people of different color, different ethnicity, young and old and middle-aged, everybody. Because let's think about this panel right now. We're talking about class actions. Class actions are representing masses of people. those people come from all different backgrounds. They're made up of very diverse factors. Shouldn't we have in leadership representation of the people who are the constituents of the class? And going back to Sheila's point about the Supreme Court, shouldn't we have people on the Supreme Court that represent the swath of our nation? That's what we're supposed to be doing. That's who we're supposed to be as America. So, you know, for me, I find now I'm not just pushing for women. That was certainly a passion and a goal. I am now also focusing on people of color, and I'm also focusing on bringing our younger lawyers up, because what's happened now, and especially because of the pandemic, our younger lawyers are not getting the same kind of hands-on experience, second chairing a deposition, going into a courtroom and sitting next to the partner at counsel table. We need to bring those lawyers up, and we need to talk to the judges and say, hi, I'm putting up this person at my firm. I'll be right there behind them. I'll be right there side by side. But we want to give these younger lawyers an opportunity. And then we have the other issue that's held back women, people of color, and younger people, and that's the financial aspect. And I know we've got something on that. You know, we can't just keep putting in leadership, oh, the same old group of guys because they made all the money and therefore they're best resourced. You know what, we're all intuitive, we're all very resourceful. We figured out ways to be very successful and able to carry on our responsibilities all on our own, whether you're in a firm structure that has somebody else's name on it or your own name.
So I would like, Kathy, if you would advance to the next slide. My toggle's not working, but I would like to discuss what you just touched on, and that is mentorship. And what I want to ask this is, what are your thoughts? What are your beliefs on whether mentorship and mentoring is important? I know the obvious answer is yes. So let's go ahead and discuss how. How do you do it within your firm? How do you help people maybe that aren't even in your firm, right? That you just want to mentor outside of the legal field, and how that could help us and help the attendees have better lives and better careers.
Well, I'll be happy to go first. When Michelle was giving her introductory remarks, it reminded me of when I was a young litigator, getting some of these discovery letters and it's like being awake at night, terrified that I was going to get sued personally or something along those lines. And thankfully, you know, I had good partners that I worked with who walked me through civil litigation and how the process unfolds. And I think it's really important, especially in those formative years when attorneys are first starting out, to not only work beside them, but also frequently check in with them and have conversations, casual ones, about how litigation is unfolding. I've noticed in particular with some of our younger attorneys that they're a little bit afraid to come into my office and just have casual conversations, even though, you know, we've repeatedly told them, please interrupt me anytime, you know, come in and talk. The younger folks, for whatever reason, they're a little bit timid. And I think part of it is because attorneys coming out of law school right now have graduated over Zoom. They've participated in class on Zoom. They haven't really had an opportunity to put themselves out there. They've been continually behind a computer screen. So the interaction that they would normally have with mentors, with folks as law clerks and things like that, they haven't had that opportunity at all. So I've now started going into their offices and sitting down and talking to them because I think having those conversations and just talking through how litigation works, the next steps of litigation, so that they don't feel so timid and they feel like they can speak up on conference calls, they could handle a meet and confer discussion, is incredibly important. And that's something that I've been trying to be more cognizant of.
Michelle, Sheila, I'd like to hear from Sheila on mentorship, yeah.
Yeah, I think mentorship is really crucial. I've always had the feeling, I've always had an open door policy, both an open door policy in my office that my door is always open, and I want people to come in and talk to me. I agree with you, Amy. I think these 2 years of COVID have been disastrous for young people. We try as hard as we can to be inclusive through Zoom, but it's not the same thing. And they can't watch the older lawyers or the experienced lawyers and the things we all learned watching our peers and the partners in our firms when we were associates, et cetera. I mean, I learned an awful lot. I learned what was good and I learned what was bad. I saw some things that I would never do, and people would say, well, who were your mentors? What women did you learn from? I didn't learn from any women. I had to learn from men, which was fine. But some of the things I was very happy to leave behind. So we have to mentor young people, both men and women, and diverse young people as well. And one of the things that I did, and if it wasn't for the pandemic, we would be out there for the last 2 years trying to build on it, is at NYU Law School, we've created a leadership program in the first year for women. We take 12 to 15 women who, and we get about 70 applications, and we give a leadership 1-week course, like a boot camp for women that early in their careers to understand that leadership for women is really important in their lives and in their careers. And we've now had 4 classes, and I can't tell you the difference it's made for these women. And we'd like to expand it. We'd like to expand it to other law schools. We'd like to expand it to many, many more women. And unfortunately, we've been held back because of the pandemic. But as soon as this is over, we're going to try to do that. And we're going to count you all in to go back to your own law schools and set these kinds of programs up, because leadership can be taught. And
Thank you.
it's not something
I got to interrupt you only because we're a little bit tight on time. I do want to ask one question to the panel that we got from Lisa Brook out of Charlottesville, Virginia. I thought this was interesting. How do you define success in your practice?
Today, every day, for the year? It's a temporal question. It could be by the minute. I would say something that I've really kind of coined now is you know it when you have the joy factor. That's when you know that you have achieved success. When you are feeling full in a very happy and grateful way. And it's not easy every day. There are some days that really stink. But when you walk away and say, I'm really grateful for what I'm doing and who I'm doing it with, because you don't have to do it anymore if you don't like it.
On that note, I want to sincerely thank Amy, Ariana, Michelle, Sheila for joining this lively spirited short 1-hour program on women in law in the class action, mass action field. I truly appreciate it. I hope we've touched some people that are here today listening in and who will listen to it on the tape. And to my grandma Lily, I hope I did you proud. Kathy, if you want to go ahead and read off the CLE information, but to you ladies, thank you so very much.
Thank you, Steve.
Thank you. This was great.
This was great. Thank you.
Thank you so much.
If you're a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 2110279N as in Nancy. Again, that's 2110279N as in Nancy. Attorneys in other states will want to check for our follow-up email on February 2nd. It will provide instructions on obtaining continuing legal education credit in Alabama, California, Georgia, Illinois, New Jersey, and New York. We are building our remaining webinar schedule for 2021-2022. Attendees should watch their email inbox for news about our future programs. Next up is crafting the effective mediation summary with Howard Marcy and Tom Kane on February 15th. And you can see the contact info for everyone on this final slide. Thank you very much for attending.
Thank you all. Thank you all very much.